that's deciding on those objections.
But counsel, you didn't take that position below. Everything you're saying, if the New Jersey Supreme Court has long held that, I thought you took the position below that the obligation attached the moment the subpoena was served.
That's not correct, Your Honor. Throughout this litigation, we have consistently taken the position that this subpoena is not self-executing. What Your Honor may be referring to is the position that we took before the Third Circuit in the Smith and Wesson case several years ago, several years before the start of this litigation. And I'll be completely candid with the Court. We took the opposite position in that Smith and Wesson case. We ultimately lost. Judge Hardiman's decision for the Third Circuit rejected that theory. And what Judge Hardiman
did, but it cited one Superior Court decision from New Jersey as authority, which is something, I suppose. But it's not the New Jersey Supreme Court. You don't cite the New Jersey Supreme Court in your brief before us. You cite the Third Circuit decision. And just looking at the statute, it says the AG subpoenas have the force of law. And if a person fails to obey the subpoena, the AG may apply to the Superior Court and obtain an order adjudging such person in contempt of court. Now, I don't know how to read that other than it's pretty self-executing to me, counsel. Now, maybe that's anomalous. Maybe that's wrong. Maybe the New Jersey Supreme Court's read it differently, but that's not the materials I have before me, so help me out.
Absolutely. So we think there are a number of reasons why these subpoenas need to be understood as non-self-executing. Having said that,
lots of reasons, but how about some authority?
Yeah, absolutely. So
what you got besides that trial court decision?
Yeah, so the New Jersey Supreme Court in Silverman v. Brooks, and there's a case that's cited in the amicus briefs at 661 A. 2nd 1274 is a 1995 New Jersey Supreme Court case. I think the Third Circuit had that before it as well. The Third Circuit, Judge Hardiman canvassed state practice in coming to that decision. Now, I do want to be absolutely clear with the Court. If you disagree with us as a matter of state law on whether or not this subpoena is self-executing.
No, I'm just trying to get to the bottom of it. That's it.
Absolutely. But
you think Silverman answers the question?
I do think Silverman speaks very strongly to that question. I will say
strongly to the question. That's a little bit different, counsel.
I do think there are background constitutional principles that make very clear that
background
the executive branch.
Okay, all right.
You were about to say, if we disagree with you, what?
Yeah. If you disagree with us and think this subpoena is self-executing, there is no dispute that petitioner would have standing from the moment of the issuance of the subpoena. There would be consequences that flow if the subpoena is self-executing from the moment of the issuance of the subpoena.
What was the date of the first occasion when your office took the position that a subpoena like this is not self-executing?
Your Honor, it was
I'm sorry, is self-executing. I'm sorry, is not self-executing. When did you first say, on the record someplace, this sort of subpoena is not self-executing?
We took that position from the start of this litigation, Your Honor.
Where would I look to see that?
So I think you would look to the petition, to the JA, for example, to our state court enforcement action, where JA 59, we're not seeking penalties for their failure to comply with the subpoena itself. All we're seeking from the state court in a production order is a obligation to produce documents. I think to the nub of your question, Justice Alito, this is the first time that we've had to directly come across a First Amendment challenge since Smith and Wesson, which is why we haven't really raised these issues prior to this litigation. We don't, as a matter of course, I do want to be clear about this, we don't, as a matter of course, seek penalties for the failure to comply with a subpoena itself.
Putting this litigation aside, wouldn't you prefer for your subpoenas to be self-executing?
Sure. The Third Circuit held otherwise in Smith and Wesson.
So do you view your position in this case, the reason that you took this position, did you view it as like you were required to take this position by the Third Circuit? Is that the issue here?
We do ultimately think that Judge Hardiman got it right in Smith and Wesson, and our job, first and foremost, is to interpret the statutes that our legislature has given us. If the legislature decided that it wanted to give the executive branch self-executing subpoena authority, we'd be happy to use that authority, but that's just not the statute.
Just putting on your lawyer's cap, you decided that Judge Hardiman was right,
Yeah, ultimately.
even though Judge Hardiman didn't command your position here.
That's right, and Judge Hardiman's opinion for the court ultimately canvassed state practice. It dealt with all of the arguments that we had made before the court. And I will say that if, again, the question that this court has is about the meaning of state law, I think there are entirely appropriate ways to resolve those questions, for example, by remanding the case to the Third Circuit with instructions to certify the question to the New Jersey Supreme Court, as is consistent with typical practice.